Hey everyone, and welcome to another deep dive. Feeling the heat of the bar exam.
Oh, it's definitely that time of year.
It is, and we know how intense it can be. So today we are diving into evidence.
Specifically, those tricky evidence questions you'll find on the MBE.
Yes, and trust me, understanding the nuances of evidence can be the difference between a pass and, well, let's just say you want to pass.
Absolutely. It's one of those subjects that can really make or break you on the bar.
And that's where our friends at Celebration Bar Review come in. You know we love them.
Uh,
They are known for breaking down even the trickiest legal concepts.
into manageable chunks. And their evidence materials are amazing.
Yes, they blend real-world cases with these super clear explanations of the rules, so you're not just memorizing, you're understanding.
Right, exactly. And I think that's what makes their approach so effective. It's not just about memorizing a bunch of rules.
It's about knowing how to apply them in real-life situations,
Yeah.
like those that you might actually see on the MBE, which is key. We're talking dying declarations, surprise admissions.
Even a dog whose bark made it into evidence.
You'd be surprised how often those seemingly bizarre cases show up on the MBE.
Right. They love to throw you a curveball. But that's why we're here, to get you ready for anything.
Exactly. So let's lay the groundwork. We're talking relevancy, materiality, competency, the holy trinity of getting evidence admitted or excluded, which is just as important.
Oh, absolutely. And Celebration Bar Review really drills these terms home. You need to know what they mean, obviously, but how to argue them. Imagine you're in court. You're trying to get a key piece of evidence admitted. You need to be able to explain to the judge why it's relevant, material, and competent. It's not enough to just throw it out there and hope for the best.
And that's where objections come in, right?
Exactly. It's like a legal chess match, you know? You need to know when to object, what type of objection to raise.
And how to do it properly. Because if you don't object properly, you might not have a leg to stand on later.
Exactly. Celebration Bar Review really stresses the plain error rule.
It's all about preserving the record for appeal.
Precisely. Now let's talk about the MBE heavyweight, hearsay.
Out-of-court statements, whispers, rumors. Why is there all this fuss?
It's all about reliability, right?
Because you can't cross-examine the person who made the statement. You can't test their credibility. So how do you know if it's accurate?
Exactly. You're kind of taking someone else's word for it, and that can be dangerous in court.
Makes sense. But of course, there are exceptions. Dying declarations being a big one. Remember our pizza guy?
Oh, yes.
His case is a perfect example of why those exceptions exist. His dying words, identifying his attacker, that could be the linchpin for the prosecution. And Celebration Bar Review uses cases just like this to make those hearsay exceptions stick.
Right, because they can be tricky. There are a lot of them, and it's easy to get them confused.
It's all about knowing when those exceptions apply. Now let's talk about admissions by a party opponent. Your own words can come back to haunt you.
Oh, it's true. Even offhand remarks, statements made without personal knowledge. Celebration Bar Review really emphasizes this. You have to be so careful about what you say, especially in situations with legal ramifications.
Because you never know what a jury might find significant.
Exactly, and they could use it against you.
Speaking of significance, let's talk about impeachment, challenging a witness's credibility.
Ooh, the art of impeachment.
Yes.
Celebration Bar Review breaks this down beautifully using prior inconsistent statements.
Exposing bias.
Even bringing up past convictions. It's like they're giving you a toolkit for dismantling the other side's case.
Love it. And let's not forget character evidence. Can you use someone's past against them?
That's a tricky one. In civil cases, generally no. You can't just say, well, this person stole a candy bar when they were 8, so they're probably liable for this car accident.
Right. It's about keeping the focus on the current case at hand, not someone's entire life story. But Celebration Bar Review highlights those rare instances where character evidence is admissible, and that can be a game changer on the MBE.
Absolutely. Those are the kinds of questions where knowing the exceptions can really pay off.
It's those little details that can make all the difference.
Speaking of details, let's move from character to tangible stuff, real and demonstrative evidence. Authenticating evidence seems so straightforward, but are there any curveballs we should watch out for?
You're right. You can't just wave a bloody glove in court without proving it's actually connected to the crime.
Exactly. Celebration Bar Review does a really good job of walking you through different authentication techniques, like that reply doctrine we talked about earlier.
Oh, yes, the reply doctrine. Using a letter's response to prove the original even existed. Clever. Clever. What about the best evidence rule? Is it really about having the absolute best evidence?
You know, not Not necessarily. It's more about ensuring the authenticity of documents. Celebration Bar Review emphasizes that if you're trying to prove what's in a document, you generally need the original.
Because a copy, well, it could be altered, right?
Exactly.
Speaking of things that can be altered, privileges. Attorney-client, doctor-patient, marital. Feels like a legal maze sometimes.
It can be, it can be. But Celebration Bar Review breaks down each privilege, explaining their purpose when they apply.
Because knowing when a privilege doesn't apply, or when it's been waived, that can be just as important as knowing the rule itself.
Right. Oh, absolutely. And these are the kinds of nuances that Celebration Bar Review really excels at explaining.
And that's crucial for the MBE, because those questions, they are all about the fine print.
Absolutely. They're designed to trip you up, so you have to be ready for anything.
Okay, let's talk about expert witnesses. They bring specialized knowledge to the court, but how do we know they're actually qualified to do so?
Right. It's not like just anyone can stroll in wearing a lab coat and start talking about DNA evidence.
Exactly. So how do we make sure that these expert witnesses are legit?
Well, Celebration Bar Review emphasizes that there's a whole process for establishing an expert's qualifications. You have to make sure their testimony is based on sound knowledge and methods. It's not enough to just be smart, you have to be credible.
It's like a mini trial within a trial, right?
Kind of, yeah.
Now, let's get specific. How do these evidence concepts actually show up on the MBE?
Well, those MBE questions are designed to test your ability to apply the rules, not just regurgitate them.
So it's not enough to just know the rule.
Right. You have to be able to understand how it works in different situations. One common theme on the MBE is leading questions. Celebration Bar Review warns students, watch out for these.
Oh, yeah. Those sneaky questions where the answer is practically embedded in the question itself.
Exact.
So are those allowed?
Well, they're generally allowed on cross-examination, but not during direct examination. Of course, like everything in law, there are exceptions.
Always exceptions. But that's why we love Celebration Bar Review. They don't just teach you the rules, they teach you how to think like a lawyer.
Absolutely. They equip you with the knowledge, A&D, the strategy to tackle those MBE questions with confidence.
Okay, let's talk about something that often trips students up judicial notice. What's the deal with the judge deciding something is a fact without needing any evidence?
Think of it as a shortcut, like a legal shortcut. It allows the court to accept commonly known or easily verifiable facts without requiring formal proof.
So things like dates on a calendar.
Exactly. Dates on a calendar, scientific laws, the fact that water boils at 212 degrees. It keeps things moving, avoids unnecessary delays. But here's where it gets interesting. The effect of judicial notice, it's different in civil and criminal cases.
Okay, now I'm intrigued. Tell me more.
In a civil case, once a judge takes judicial notice of a fact, it's considered conclusively established. The jury, they have to accept it as true. But in a criminal case, the jury, they have a little more wiggle room. They can still choose to disregard the fact, even if the judge has judicially noticed it.
Wait, really? So if a judge says it's a known fact the sky is blue, a jury in a criminal case could still be like, nope, we're seeing gray today.
Technically, yes, though convincing a judge to even allow that argument would be, well, quite the feat. But it really underscores that higher burden of proof in criminal cases and the protections that are afforded to defendants.
It's fascinating how those distinctions play out in evidence law. Celebration Bar Review really hammers home the importance of context.
Oh, they do, and for good reason. You can't just memorize rules in isolation. You need to understand how they operate in different situations.
Oh.
And Celebration Bar Review, they just excel at making those connections for students.
Speaking of connections, let's jump back to impeachment. What about prior inconsistent statements? Those always seem right for MBE questions.
Right, you are. Celebration Bar Review reminds students that the MBE loves to test your understanding of the nuances surrounding these statements. It's not enough to just know that you can use them to impeach credibility. You need to know how the rules change depending on the circumstances.
Okay, break it down for us. What are we watching out for?
One key distinction is whether the prior inconsistent statement was made under oath. If it was just a casual conversation, you can use it to impeach the witness's credibility, but it's not considered substantive evidence. It can't be used to actually prove the truth of what was said.
So it's like saying, we're not so sure we believe you NW, given that you said something different before.
Exactly. It's about casting doubt. But if that statement was made under oath, say during a deposition or prior testimony, then it can be used for both, impeachment and as substantive evidence.
Ah, those little details. Celebration Bar Review probably has a whole mnemonic device for remembering that one.
Probably. They're masters of making the complex clear. And speaking of potentially complex, let's talk about impeachment with prior convictions. Can you just bring up someone's criminal past willy-nilly to discredit them?
Because it seems like that could really bias a jury.
Oh, you're right, it could. And that's why there are rules in place to ensure fairness. Generally, only convictions that involve dishonesty or false statements, those are automatically admissible. And even then, there are time limits.
So you can't just dig up a decades-old DUI to make someone look bad.
Not unless you can convince the judge that it's relevant to the witness's truthfulness and that its value as evidence, that it outweighs the potential prejudice.
Makes sense. It's a balancing act. Now, what about when it comes to impeaching a criminal defendant who chooses to testify? That seems like a whole other ballgame.
Absolutely. Celebration Bar Review dedicates a good chunk of their materials to this very issue. The stakes are much higher because the defendant's credibility, it could make or break their case.
So what are the specific rules there? Walk us through it.
If the defendant has a conviction for a crime involving dishonesty or false statements, and it's within the past 10 years, that conviction is usually fair game. But for other types of convictions, the judge has to weigh the probative value. How useful is it in determining guilt or innocence against the potential prejudice to the defendant?
So it's a judgment call for the judge. They really have to weigh those factors carefully.
Well, they do. It's about protecting the defendant's right to a fair trial and making sure the jury isn't assuming guilt just based on past mistakes. Everyone deserves a fair shake, regardless of their past.
Absolutely. Okay, let's shift gears a bit and talk about authentication again. We touched on the reply doctrine, but what are some other common ways to prove that evidence is what it claims to be?
Witness testimony is a big one. Someone who wrote a document, signed it, is familiar with someone's handwriting, they could authenticate it.
So if I wanted to authenticate a letter my grandfather wrote, I could testify that I recognize his handwriting.
You got it. Or for business records, someone familiar with the company's record-keeping practices could authenticate them.
Makes sense. What about physical objects? How do you authenticate those? It can't be as easy as just saying, yep, that's the candlestick, all right.
Not quite. That's where chain of custody comes in. Celebration Bar Review really emphasizes how crucial this is for authenticating physical evidence, especially in criminal cases. It's all about showing who had possession of the evidence at every stage, from the moment it was collected to the time it's presented in court.
Like a paper trail, but for physical evidence.
Exactly. Let's say the police seize a gun from a suspect. To authenticate that gun in court, the prosecution, they would need to present evidence from everyone who handled it. The arresting officer, the evidence technician who processed it, anyone else who touched it along the way.
So you're preventing someone from claiming, hey, that's not the same gun, you swapped it out.
Precisely. The chain of custody ensures the integrity of the evidence, and it prevents those accusations of tampering or contamination. And Celebration Bar Review really stresses the importance of being able to spot weaknesses in the chain of custody, because that can be grounds for excluding evidence.
Like a game of connect the dots, making sure those dots line up perfectly. Speaking of connecting dots, let's circle back to privileges. We've got attorney-client, doctor-patient, marital. What are the key things our listeners need to remember about these?
The MBE loves to test on privileges. Celebration Bar Review really emphasizes that understanding the purpose behind each privilege, that's key. It's not about hiding information. It's about protecting certain relationships, encouraging open communication.
So with attorney-client privilege, it's about ensuring that clients feel comfortable being completely honest with their lawyers.
Exactly. Without that privilege, clients might hold back crucial information for fear of it being used against them. And that could really hinder their lawyer's ability to represent them effectively.
It's about building trust and fostering that open dialogue so lawyers can provide the best possible defense. Now, are there ever situations where attorney-client privilege doesn't apply?
Absolutely. Celebration Bar Review makes it very clear that there are exceptions. For example, if a client tells their lawyer they're planning to commit a crime, that's not protected. The privilege doesn't shield ongoing or future illegal activity.
Okay, that makes sense. You can't use privilege as a shield for criminal intent.
Yeah.
What about doctor-patient privilege? What are the key takeaways there?
The doctor-patient privilege is all about encouraging patients to be upfront with their healthcare providers. Without it, patients might withhold crucial information about their symptoms, their medical history, and that could lead to misdiagnosis, improper treatment.
So it's about ensuring patients get the best possible care without fear of repercussions.
Exactly. But like with attorney-client privilege, there are exceptions. For example, if a patient's mental state is at issue in a court case, their communications with their therapist might not be protected.
So it's a balancing act, protecting privacy, but also ensuring fairness in legal proceedings. What about marital privileges? Those always seemed a bit more, I don't know, complicated.
You're right. There are actually two main types of marital privileges. The first one protects confidential communications between spouses during their marriage.
So, like those late-night conversations that are meant to stay between husband and wife.
Precisely. The law recognizes the importance of privacy in a marriage, and this privilege helps to safeguard that. However, this privilege, it only applies to communications that were intended to be confidential.
So, an argument overheard by a neighbor in the backyard wouldn't qualify.
Probably not. Now, the second type of marital privilege is a bit different. It applies only in criminal cases, and it allows one spouse to refuse to testify against the other.
Wow. So a spouse could choose to stay silent, even if they have information that could help convict their partner.
In many cases, yes. But Celebration Bar Review really emphasizes that this privilege belongs to the witness spouse, not the defendant spouse. So if the witness wants to testify, they can.
So it's not like a get-out-of-jail-free card that a defendant can just whip out whenever they want.
Exactly. And like with the other privileges, there are exceptions. For example, in cases of domestic violence or crimes against children, the privilege might not apply.
Because in those cases, the need to protect the victim outweighs the need to protect marital privacy. It's all about finding that balance. Now, let's dive into some more specific evidence rules that often trip students up on the MBE. First up, the best evidence rule. Is it really as straightforward as it sounds?
It can be a bit deceiving. Celebration Bar Review always cautions students, don't get tripped up by the name. It doesn't mean you have to present the absolute best evidence available. It's more about ensuring the authenticity and accuracy of documents when their contents are at issue.
Okay, I see where the confusion might come in. So if you're trying to prove what's written in a contract, you generally need to produce the original contract itself, not just a copy.
Exactly, because a copy, well, it could be altered or incomplete. But of course, there are exceptions. If the original is lost or destroyed through no fault of the party trying to present it, secondary evidence, like a copy or even oral testimony about the contract's contents, might be admissible.
Ah, those exceptions are always lurking. What about the parole evidence rule? That one always sounded kind of intimidating.
It's not as scary as it sounds. Celebration Bar Review does a great job of demystifying this rule. It essentially prevents parties to a written contract from introducing evidence of prior or contemporaneous agreements that contradict the terms of the written contract.
So it's like saying, what's in writing is what matters. We're not going to entertain claims about side deals or promises that weren't included in the final version.
Exactly. It's about upholding the integrity of written agreements and preventing parties from trying to change the terms after the fact.
Makes sense.
Yeah.
It brings a sense of finality to written contracts. Now, what about subsequent remedial measures? That one always seemed to be rooted in public policy.
You're right. It's all about encouraging people, companies, to make things safer without fear that those actions will then be used against them in court.
So if a company fixes a faulty product after someone is injured, that fix can't be used as evidence that the product was defective in the first place.
Generally, that's correct. It's to prevent a chilling effect on safety improvements. Because, let's face it, companies might be hesitant to fix dangerous products if they knew those fixes could be used against them in court.
So it's in everyone's best interest to encourage those safety improvements, even if it means excluding some potentially relevant evidence.
Exactly. It's a trade-off, but one that ultimately promotes public safety.
I like how these rules often reflect those bigger picture considerations. It's not just about winning or losing a case. It's about fairness, safety, and justice.
Precisely. And Celebration Bar Review really emphasizes that holistic understanding of the law. It's not just about memorizing rules, it's about understanding their purpose and their impact on the real world.
Speaking of impactful, let's talk about the big one, the privilege against self-incrimination. The Fifth Amendment, right?
You got it. It's a cornerstone of our legal system, protecting individuals from being forced to testify against themselves.
I plead the Fifth. We've all heard it a million times on TV, but what does it really mean?
It means you can't be forced to provide testimonial evidence statements, communications that could be used to incriminate you in a crime.
So it wouldn't protect someone from being fingerprinted or giving a DNA sample.
Right. Those are considered physical evidence, not testimonial.
And this privilege, it applies in all legal settings, not just criminal trials.
That's right. Civil cases, administrative hearings, depositions, any situation where someone is being compelled to give testimony that could incriminate them.
Wow, so you could plead the Fifth even if you're being questioned in a civil lawsuit.
Potentially, yes. If your answer could expose you to criminal liability, it's all about protecting your rights.
It's amazing how many different scenarios these evidence rules apply to. It seems like Celebration Bar Review, they really have their work cut out for them, trying to prepare students for all of that.
They do, but they do it well. They break down these complex concepts and equip students with the knowledge and the skills they need to succeed, not just on the MBE, but beyond.
They're like the evidence whisperers.
Hmm.
Okay, let's talk about another MBE favorite. Character evidence. When can you use someone's past against them? And when is it totally off limits?
That's a question that often trips students up. But Celebration Bar Review does a great job of clarifying the rules. It's all about balance. In civil cases, for instance, character evidence is generally inadmissible if it's being used to prove that someone acted in conformity with that character. It's considered too prejudicial, and it could mislead the jury.
So you can't just say, this person cheated on a test in high school, therefore they must have committed this fraud?
Exactly. The focus should be on the facts of the current case, not on painting someone as a bad person based on their past.
It's about keeping the playing field level. Now, are there any exceptions to that rule? When re-ask character evidence admissible in a civil case?
Celebration Bar Review has a whole section dedicated to those exceptions. For example, if someone's character is directly at issue in the case, like in a defamation lawsuit where the plaintiff's reputation is being challenged, then character evidence might be admissible.
So it's all about context. What about in criminal cases? Are the rules different there?
They are indeed. Celebration Bar Review emphasizes that in criminal cases, the defendant can sometimes introduce evidence of their own good character as it relates to the crime charged. It's a way for them to say, look, I'm a good person. I wouldn't do something like this.
So it's a way for the defendant to try and cast doubt on the prosecution's case by highlighting their positive traits.
Exactly. But here's the catch. Once the defendant opens that door and introduces evidence of their own good character, the prosecution is then allowed to rebut it with evidence of the defendant's bad character.
So it's a risky strategy for the defendant. They have to weigh whether the potential benefits outweigh the risks.
Precisely. And that's where having a skilled attorney who understands the nuances of evidence law is absolutely crucial. They can help the defendant make those informed decisions about what evidence to present and how to navigate those tricky rules.
It's like a strategic game of chess, isn't it?
It absolutely is.
Now let's move from character to physical objects, real and demonstrative evidence. Authenticating evidence seems straightforward. But are there any curveballs we should be aware of?
You're right. Authenticating evidence is usually pretty straightforward. A witness can testify that a document is what it claims to be, or that they saw it signed. But there are some interesting nuances. For example, did you know that even a dog's bark can be considered evidence?
A dog's bark. Now that's something you don't hear every day. Tell me more.
There's a case where a drug-sniffing dog barked while examining a suspect's suitcase. The prosecution wanted to use the dog's bark as evidence that the suitcase contained drugs.
And could they do that? Could a dog's bark really be admitted as evidence?
The court said yes. Because the dog had been specifically trained to detect narcotics and to bark when it found them, the bark was admissible as evidence of the dog's reliable habit.
That's fascinating. So the dog's bark wasn't treated as hearsay and out-of-court statement, but as evidence of a trained response.
Exactly. And it highlights an important distinction in evidence law sometimes. Actions can speak louder than words.
I love that. So a dog's bark or any other action could be admissible as evidence if it's shown to be a reliable habit.
That's the key, reliability. The court has to be convinced that the action is consistently linked to a particular circumstance. In this case, the presence of drugs.
Okay, so we've got talking dogs, dying declarations. Evidence law is anything but boring. What other interesting cases can you share that illustrate these key concepts for our listeners?
Well, there's a case where a witness was allowed to testify about the contents of a document, even though the original document was lost in a fire.
That makes sense. It seems kind of unfair to punish someone for losing evidence in a fire. But wasn't there a rule about always presenting the original document? The best evidence rule.
You're right. The best evidence rule generally requires the original document to be produced. However, there are exceptions, and this case fell under one of them.
Because the original was destroyed through no fault of the party presenting the evidence.
Exactly. The court recognized that it would be impossible to produce the original, so they allowed secondary evidence, in this case, the witness's testimony about the document's contents, to be admitted.
So sometimes a good story can be just as good as the original document.
In certain circumstances, yes. But it's important to note that the court has discretion in these situations. They'll consider factors like the reason for the original's absence, the reliability of the secondary evidence, and whether there's any reason to suspect fraud or bad faith.
I can see how those factors would be important to ensure the integrity of the evidence. What other interesting cases come to mind?
There's another case that illustrates the concept of adoptive admissions, something Celebration Bar Review specifically calls out as a potential trick question on the MBE. A company was sued for false advertising, and during discovery, the plaintiff asked for information about the company's sales figures. The company directed the plaintiff to a trade publication that regularly published sales data for companies in that industry.
So the company essentially said, go look it up in this journal.
Yes. And because they specifically directed the plaintiff to that publication as a source of accurate information, the court considered it an adoptive admission.
Meaning they adopted the contents of the journal as their own.
Precisely. The court treated it as if the company had published those figures themselves, making them admissible as evidence.
That's a clever use of the rules. It shows how important it is to be strategic in your use of evidence.
Absolutely, and it underscores how a deep understanding of these rules can really give you an edge in court. And that's exactly the kind of strategic thinking that Celebration Bar Review encourages.
Absolutely, and it just goes to show you can't underestimate the power of a good argument. And that's something that Celebration Bar Review really emphasizes, understanding not just the rules of evidence, but how to use them strategically in court.
It's like they always say, it's not enough to know the law, you have to know how to play the game.
Exactly. And evidence law, well, that's a big part of the game.
It is. It's like a game of strategy, knowing when to play your cards, when to hold back.
And when to object.
Oh, yes, those objections. So important.
Absolutely, because if you don't object at the right time, you could waive your right to challenge that evidence later on.
Exactly, which is why Celebration Bar Review really drills those objections into their students' heads. They give them all the tools they need to spot those objectionable pieces of evidence and raise those objections effectively. And that's crucial. Because you can know all the evidence rules in the world, but if you don't know how to apply them in a courtroom setting, well, it's not going to do you much good, is it?
Not at all. So, to wrap things up for our listeners today, any final words of wisdom, especially for those who might be feeling a little overwhelmed by all these evidence rules and exceptions?
You know, I would say this: don't be discouraged. Evidence law, it's a challenging subject, there's no doubt about it, but it's also incredibly interesting and intellectually stimulating. And with a little bit of effort and the right guidance, you can absolutely master it.
And remember, you don't have to do it alone.
Sure.
Celebration Bar Review is there to support you every step of the way, providing the knowledge, the strategies, and the confidence you need to succeed on the MBE and in your legal career.
Absolutely. They've got your back.
They do. A huge thank you to our expert for joining us today and for breaking down this complex topic in such a clear and engaging way.
It was my pleasure. Thanks for having me.
And to our listeners, best of luck with your bar prep. Remember, you got this. And until next time, stay curious and stay informed.